So a trustee comes to the end of the trust administration and they want to be done with it. They want to make a final distribution, but they don't want to be sued later down the line by the beneficiaries. So naturally, they want the beneficiaries to sign a release and waiver. The problem is that there's 5 different avenues that a beneficiary can use to set aside that waiver and release at any point in the future. The first one is if the trustee makes signing a release dependent upon getting a trust distribution. So if you hold back money from a beneficiary and you make them sign that paper first, then that release is no good and it's going to be thrown out by the court. A release is also no good if the beneficiary lacks capacity, if it's obtained by the trustee doing some bad act, so lying, fraud, that sort of thing. If the release is obtained through an unfair bargain, so there's some sort of an unfair bargain going on between the trustee and the beneficiary, or if a trustee has not fully disclosed all material facts and the rights of the beneficiary before obtaining the release. How is a trustee supposed to properly obtain a release or a waiver from a beneficiary? Well, my first piece of advice is don't. Instead, go to court and get your accounting and your actions as trustee approved by the court. Once you file in court, then the beneficiaries have the right and the obligation to come forward and object to what you've done if they're going to do that. If there are no objections, or if the court rules over their objections and approves your accounting, then the door is closed. It's a done deal, and nobody can come back and challenge the actions that are disclosed in the accounting at a later time, because the court's already approved all of those actions and you are done. If, however, you don't want to go to court with a court-approved accounting, then at least follow some simple steps in order to try and protect yourself as trustee. First of all, do not ever make a release subject to getting a trust distribution. And in order to prove that, what you want to do is make a preliminary distribution of trust assets, get out as much of the assets as you possibly can. You certainly are entitled to keep a reasonable reserve held back in the trust, but at least get as much assets out as possible before asking a beneficiary to sign a waiver and release. That way you can prove that you did not withhold distributions subject to them signing. Secondly, you're going to want to ask the beneficiary to have them review the waiver or release with a lawyer of their own choosing so that they can understand what the document is and what it is that they're signing. And third, you want to fully disclose everything. So everything you have, every financial information, every understanding about whatever transactions have occurred in the trust, you want to provide all of that to the beneficiaries. Give them the bank statements, give them the financial statements, give them the closing statements if you sold real property, give them the entire escrow file that you got from escrow. Let them see everything, because if you hold back anything at all, that could form the basis of a lawsuit later on in the future. If you're a beneficiary and you're being asked by a trustee to sign a release and they're withholding distributions, do not sign. In fact, don't ever sign any document from a trustee that you do not understand. This is very important. Talk about it with a lawyer. Have them take a look at whatever you're being asked to sign, and if all else fails, go to court. You're going to have to go to court to stand up for yourself in order to make sure that you get what's right out of your trust. Don't just assume that all the documents that you're being given are perfectly fine to sign, especially if you don't understand them.